In a rather unprecedented move, Edmonton Police have come out publicly against a plea deal in a shocking and horrific child murder case. As you can imagine, that sparked all kinds of reaction, including from Alberta's premier. We'll take a closer look at this controversy next on The Line, Alberta. Hey folks, welcome to the Line Alberta Podcast. My name is Rob Breakenridge. Plea deals are hardly uncommon or unusual in our criminal justice system, but the reaction to one such deal in Edmonton has been anything but usual. It sparked quite a debate about our system, our punishment, and the lines that exist in the jurisdiction around how that system is administered. Later on, we'll hear from defense attorney Deborah Hatch, who's also an Alberta director with the Canadian Council of Criminal Defense Lawyers, and they're very alarmed at what's transpired here. Also, coming up in just a moment, we'll hear from a former Crown prosecutor and executive with the Canadian Police Association and get a different perspective on this case. Now, this all concerns a plea deal and what was supposed to be a murder trial of a woman in connection with the death of an 8-year-old girl. Earlier this month, though, the Edmonton Police Service sent a letter denouncing the Crown's decision to accept a manslaughter plea rather than proceed to a murder trial. That letter was sent by then Interim Police Chief Warren Dreichel and signed by EPS lawyer Megan Hankiewicz. While acknowledging the intervention as an extraordinary step, the letter describes the plea agreement as a miscarriage of justice. It even calls on the Provincial Assistant Deputy Minister of Justice to intervene. And there was also a warning in that letter that if there was a plea deal, police would release key details in the case that have so far not been made public. So as noted, and as you can imagine, that letter has sparked quite a debate. Alberta Premier Danielle Smith even weighed in to defend what the Edmonton Police Service did, suggesting that if the Crown isn't going to go to trial, the public needs to understand why and why they made that decision. Since the letter was made public, Dreichel has been sworn in as the new police chief of the Edmonton Police Service and has taken some steps to back away from the original letter. Dreichel told reporters last week that, quote, "We're hoping we don't have to do that again." He says, quote, "It was a last resort for us to try to get some kind of traction or motion forward. This was about us trying to open up that dialogue." So let's do just that, open up a dialogue. There's a public interest in the death of a child and making sure someone is held responsible for that. There are also lines that exist in our system for a reason and a slippery slope if those lines are blurred or erased. In this episode, we'll bring you a couple of different perspectives on this case and some of the broader issues. Up first, a conversation with Scott Newark, a former Alberta Crown prosecutor who has also worked with the Canadian Police Association and in public security roles with both the federal and Ontario governments. Here's that conversation. All right, well, joining us for some further perspective on this case in Edmonton, very pleased to welcome to the Line Alberta, Scott Newark. He's a former Alberta Crown prosecutor. He's a former executive with the Canadian Police Association, also former vice chair of the Ontario Office of Victims of Crime, and worked as a security advisor to both the Ontario government and the federal government. Scott Newark, great to have you with us here.
Thanks. Great to be with you.
So as I say, you've seen the system from kind of all sides. You look at the frustration that obviously Edmonton Police were feeling with how this case was handled, the decision to speak out this way. I mean, first of all, is it anything like you've ever seen before?
The frustration itself is not necessarily new, but the manner in which the Edmonton Police conveyed it publicly, that is something that I don't think I'd ever seen before. Although, and as I think you know, there's been recent media reporting as well about, with all of the concerns about repeat offenders and high-risk offenders, police organizations, including police associations and police departments, police leadership, are speaking out, and premiers are speaking out more than they probably ever have before with the need for reform. This one, and I was alerted to this case, by the way, by a former minister that I used to work with, because, he saw the same thing and went, wow, what's going on? Yeah. And the thing that really struck me about it was, I think, and I'm, probably still of the same opinion, the impropriety of the police taking the step that was to make these discussions public.
Right.
Because that was, it compromises potentially the independence of the different institutions, which is a cornerstone of our entire system. And look, I had, disagreements with police over the years as well too, but I also had the relationships that we were able to work it out and we trusted each other. This one, wow, doesn't seem to be the case. And one of the things that after you and I first got together and talked about this, I started digging into the media. And one of the things that I noticed was that the head of the Edmonton Police Service Legal Division, very bright woman named Megan Hersbach or something. Guess she's the head of the legal department at the Edmonton Police Service. Guess what her job was before that?
I don't know.
She worked for the Crown.
Oh, no kidding.
Something going on here. And the guy who was the chief of police, Edmonton Police, in the years in which all of this was leading up, he's also got a new job. He's the deputy minister to the premier of Alberta and cabinet. His name's Dale McPhee. He's a very bright guy. Yeah. So, I'm seeing all this stuff. I'm sort of going, what's going on here? This doesn't seem to make an awful lot of sense. And it's very hard to find the details of what the actual allegations are. And again, the real source of information that I've been able to get has come from the media. And I think that goes to what, we were talking about before, the absolute importance of an informed and independent media to make sure the public knows the truth about what the hell is going on. And if there are problems with things, that's critical. And I think this case is an absolute example of that.
Yeah, that's a great point. I think it's highlighted a lot of important issues with what's going on within the system right now and some of the frustration that it almost seems to be boiling over. From the Crown's perspective, and you've been there, the pressure of dealing with the case or the decision to try to come to some sort of plea agreement, what goes into those sorts of decisions?
Well, it's the defense has to be satisfied that you're going to be able to prove what you say you can prove.
Right.
But it's funny. This is something that it's a long story. I won't bore you with the details of it. But in I think it was 1981 when I started as a prosecutor in Wetaskiwin Judicial District, and I ended up accidentally becoming a special organized crime prosecutor. As a result of the disruption of bike gangs back in the days. And the really important thing was that it connected me to the RCMP intelligence unit. And as a result of that, I got access to the information on files going forward, for decades. Wow. And that was what helped, if you want to get the right answers, you got to ask the right questions, that kind of thing. And so that's what happens. And I think in many ways, though, our system has actually ended up unintentionally rewarding, delays in the system. Because the longer something gets delayed, the more somebody can go, oh, no, my charter rights have been violated. And so, we're going to bring an application. And it almost becomes an incentive for people not to consider a guilty plea and to get things done. And as one of my friends that was in the RCMP Intel unit once told me, if you want to be successful as a prosecutor in that, you got to be able to think like the bad guys do. Absolutely true. And that's something that I think what seems to me to be there's some frustration is that it sure doesn't sound like the communications between the Crown and the police were very good. And, when you read some of the comments, oh, well, yeah, we hadn't heard for months. And even some of the stories from the little girl victims' families said that they weren't getting communications from the Crown. That's not the way the system's supposed to work.
No.
And
what is that? Yeah.
Well, I was just going to say, I think it leads to the kind of dissatisfaction and, pressures that can produce results like this. I've got more questions left than answers as I've gone through all of the media stuff. Like, it appears this little girl was Indigenous, and one of the latest stories says that the woman who ended up having custody of her had been contacted by the little girl's father, who was in jail. Does this mean that, for example, child welfare was involved? I don't know. I've never seen anything like that. But, there's allegations, of course, I know you're familiar with them, that before the actual events that led to her death took place, supposedly confirmed by the accused's own children, she was physically abusive of this little girl for, probably a couple of years. And again, as I say, was child welfare involved in this? Did they know about it? Why didn't they do anything about it? Those are the kinds of questions that I think remain unanswered. And most importantly, and I've had some experience in this as well, too, things like in Ontario, we call them inquests. In Alberta, they're called fatality inquiries. And there was just one done in relation to a personal services worker in Calgary, I think it was, who was knifed to death by some guy who was staying at the care home. And it took a number of years, but ultimately there was one of these fatality inquiries. And so a whole bunch of recommendations were made, because it turns out that the system, nobody told her that this guy had previously, caused harm to workers before. Like, that's not the way things should work. And I saw that in the remarks of the newly appointed chief of police in Edmonton, who, by coincidence, was the guy who supposedly sent this letter to the deputy attorney general. Yeah. And he actually makes the point. I don't think I know him, but he sounds like a pretty reasonable, sensible guy, because he said, there's things within the system that could have prevented this kind of thing happening, and it didn't work. Those are the kinds of things we need to look into on a public interest thing to see if we can prevent this kind of thing from ever happening again, instead of just pointing fingers.
Yeah, that's an important point, because right now the conversation is about, well, how do we deal with this mess after the fact and this horrible tragedy, and what's appropriate in terms of sentencing and all of that. But, the whole question of, did this even need to happen in the first place, or could this have been prevented much sooner, right? And that's beyond the purview of anything the Crown has responsibility for.
Yeah, and as I mentioned a little bit before, I've been involved in this on different cases as well, too. And it helps to have the background of, so that you're aware of what the system could have done. And one of them was that turned out to be very important. It was the murder of a little boy named Christopher Stevenson by a career criminal named Joe Fredericks in Ontario. And he had been released, should never have been, but he'd been released from prison. And, you have to give where I'm going to be living and everything else. Well, it turns out he just moved away and never told the Correctional Service of Canada supervisors where it was happening. Mm-hmm. And so the Ontario government, to their credit, decided to call an inquest into this and look into it. And that was all exposed. And as a result of that, guess what? That's where the sex offender registry came from. Ontario did it first, and then the federal government, after we pushed them on it, ultimately did it as well, too. And we now have that national system. So there are definitely examples of where, when, as I say, you focus on problem solving, not finger pointing, you can get information out things and realize, okay, this is one area where, we need to change things. And I'll give you just one other point about this, too, is that I frankly, in many ways, look at this institutionally, I think, because, ours is a system, and it, notwithstanding what the federal authorities may think, our justice system wasn't created last month by the Federal Department of Justice in Ottawa. It's been part of our culture for hundreds and hundreds of years. And there are foundational principles to it, like the independence of the public officials, police, prosecutors, judges.
Yeah.
Okay? That's important. And things that undermine that have potential significant negative consequences. And I remember when we set up that Ontario Victims of Crime office, and we were doing sort of interviews all around the province. And a big part of it was the province wanted, or the government, not the administration, but the government wanted us to look into things to see if there were changes that could be made administratively and systemically that would help victims of crime. And I was doing the research on a lot. We were doing interviews all around the province, but I found a report that was produced by prosecutors in Ireland who were also reviewing their system, and they said that the line that I was struck by the most was independence and accountability are important concepts, but they should not be irreconcilable concepts. Good point. Good point.
I want to come back to that relationship that exists between the Crown and the police, because it's a partnership in some ways, but of course there's walls there and there's independence there.
Yes.
But I think this case illustrates that for police, it's not just they do their investigation, prepare the notes, just hand over the evidence and wash their hands of it, right? And they're, I mean, at some level, it shows that this matters to them, that they care about what happens with these cases.
Yeah. Right? Yeah. Oh, absolutely. No question about it. And I mean, that's what I found. Exactly what you just described was what helped build the relationship that I was able to get with starting with the RCMP, the serious crime, and was that they really sincerely appreciated the fact that there was somebody who was a prosecutor who was going to do something about, a situation and fix a legal problem. Because the case where I got involved with, little town on my circuit was Camrose, and I drove in there one morning, and I drive up in front of the courthouse, and there's like 50 motorcycles parked. And I'm like, what the hell is going on here? And I go in, and it turns out what it was is that all the different bike gangs in Alberta, and this is, I say, before the Hells Angels took over, they would have annual meetings in a little town called Coronation, to the south of Camrose. And they were business meetings, but they'd also rough things up and rape a couple of the local town girls sort of thing. And nobody ever did anything about it. And then, I think it was in 1981, and the RCMP said, nah, you know what, we're going to go bust this up. And so they went, and they wrote all of these tickets for these guys. I used to refer to them as being under the Poultry Act because they were all chicken. It was like section 42.1B, motorcycle seat too low sort of thing. It was a $40 ticket. But I mean, I get there and there's all these bikers and lawyers, everything else. And this, the judge who was there, Alec Murray, we got to be really, really good friends. And this is before the charter. And I'll tell you something, that's an important aspect, I think, from a systemic perspective, because I got to see things before the charter and after the charter, and including as the charter developed. And we are increasingly in a juristocracy, in my opinion. But they made the argument, oh no, these charges happened in Coronation, and they shouldn't have been returned to Camrose. The police made a mistake, so they should be all thrown out. And the judge, who people mistakenly thought, oh, he must be left wing, because he did. He threw them all out. And in fact, he wasn't. He was a very libertarian kind of a guy, and thought that what they had done was wrong. But as you can imagine, this got a whole lot of media attention, the fact that the police had broken this up. So I come out of the court, and there's a whole bunch of reporters out there, with the microphones up kind of thing. And they said, well, what are you going to do? And I said, well, let me put it this way. I didn't go to law school to help promote the interests of bikers. Okay, so I said, we're going to appeal every one of these cases. We're going to win, and we're going to come back, and I'm going to prosecute in each and every one of the cases. And again, as you can imagine, that got a lot of media attention because of the importance of the case. And I was, very young into the career, and I didn't realize the department had a policy that said if there was an appeal that was required, you had to get permission from head office to appeal it. And I didn't know that, so I had said that I'm going to do it, but because it was such a high-profile case, head office didn't want to overrule me, so I was allowed to go and appeal all the cases, which I did, and I won. And we came back into court, and I said, we can send them all down to coronation if you'd like, or we can even just leave them here and I'll prosecute them here. And you could see all the lawyers, defense lawyers, looking at each other and going, hey, we should keep it here. This judge is on our side. He's already thrown them all out. Let's leave it here. So we did. And it was back in those days, you were able to do a case on a ticket within a matter of, half an hour kind of thing. A little bit longer these days. But so we did, and we started rolling through them all and getting convictions on all of this stuff. Because as I say, this judge was an excellent judge. And at one point, the bikers start looking at each other and going, hey, this is like a $40 ticket that I got, and I'm paying my lawyer $5,000.
Yeah.
So they pled guilty to everything. And that was, how it was a really good insight into the systemic way that the system can work. Mm-hmm. And it did. In those instances, it did. And it built relationships. And I'll tell you, the cops that I was working with really appreciated the fact that they had somebody who was willing to go to the wall to get the right result, and right. That's what worries me the most about what I've seen about this case is, man, I sure hope that this doesn't do any sort of long-term damage to the relationship. I don't think it will, especially because the new chief of police now in Edmonton, of course, is the guy who, yep. was the one who actually wrote the letter, or sent the letter at least. But people need to understand how important those relationships are and how important it is that there be that independence. That's what I think is the most important. And also, as you mentioned before, and I believe it was a couple of days ago, they went to back to court and have finally set a court date for sentencing. I haven't been able to find it, but let's go through all of this, but then also let's learn from the circumstances of this. Number one, about the relationship, I think, between the police and the Crown, so this kind of stuff doesn't happen again. And as I say, not so much focused on finger pointing as on getting the right results, but also, and this is what struck me when I started reading this, and I've become sort of a policy geek that way, is the potential for, let's take a look at this and make sure that in the larger systemic context, this is not something that could have been prevented. Because this is a horrific crime. And how is it that this little girl ended up in the circumstances? And, I understand all about, we can't name people and, everything. Yeah, sure, fine. But let's learn from it. Because if child welfare was involved, they obviously didn't do what they should have done. Or if they weren't, why not?
Right.
And how do you handle that? That's important because you don't ever want to have this happen again.
Yeah. I think you spoke to an interesting element. And I think, even in a case like this and everything the police went through in investigating this case, and something like this is going to take a toll, but, the amount of work that goes into gathering the evidence, building a case. And I guess, having that faith or that trust and knowing that you got a partner in the Crown, that this is not all going to be for naught, right? That we'll do our part and they've got our back sort of thing, right?
Yeah, and that there's the motivation, and it's from what I've read in the media. Several people have said that the guy that was responsible for the prosecution is somebody who's got a long history, a credible history as well too. Mm-hmm. So that's why I think it's entirely appropriate to look at this sort of on the inside and go, well, how did this, misunderstanding come about? And look, in all fairness, sometimes it can just be personalities. You never know what's going on. But there needs to be, I think, the appreciation of the importance of the cultural issues that we discussed a couple of minutes ago, because, I also have a background in history. And for example, there's a reason why the name of the case is Regina versus so-and-so. And it's not because all crimes happened in Saskatchewan.
Right.
Okay. It's the Crown.
Yep.
Okay. And by the way, the Crown represents the people. That is what is so important. And that's what I found so honorable about working as a Crown prosecutor, Rob. It was funny because when I was in law school, I went to the University of Alberta Law School. I'd actually gone to Carleton University in Ottawa before then. They actually have an undergraduate law program that was really good. And I decided, I think maybe I'd like to go to law school. So I applied to a whole bunch of schools, and the University of Alberta in Edmonton had something that was unique to me and made me select the University of Alberta. And what it was is they were the only one that accepted me.
Yeah,
but along the way, they had a program called Student Legal Services. And as students, we got to go and help represent people on summary conviction offenses. And I was there, and this would have been in the 70s, late 70s, I guess. And I ended up getting the law that said that it was in the criminal code that the police could seize weapons from somebody, firearms from somebody, with a court order or without, in defined circumstances, if they thought they posed a risk to society. Okay, it was a preventive kind of a law. And so I went to court on this one case, and I always remember it was these two couples who had their guns seized, and one of them, when they got married, instead of exchanging rings, they exchanged guns. So I but I said, hey, look, here's what the criminal code is, and that's federal jurisdiction. And the province under section 9212, 9221, I think, they have the responsibility for the administration of justice. So this is provincial jurisdiction, not federal jurisdiction. These are unconstitutional. And back in those days, that meant in relation to the British North America Act. And the judge agreed, and he, struck down all of the cases and threw them all out. And it was very high profile. So everybody assumed I was going to become a defense counsel. But it was a really eye-opening experience for me, because it dawned on me in a real-life situation how important the justice system was for our society, and the public benefit that the citizens of our society get from when the system works as it's intended. And that's what I find so concerning about this particular case, is just it's an insight into something that this system is not, or didn't work, I shouldn't say in an ongoing basis, but it didn't work the way as originally intended, and not just last month, but for centuries. And that it's the public that at large is affected by this in a negative way, potentially. So that's why I think it's really, really important that there be some kind of ongoing analysis of this. And I sincerely hope that the media continues to focus on this and tell the public what's really going on.
Yeah. And I asked you earlier about what goes into deciding to pursue a plea agreement, from the perspective of a Crown prosecutor. And I think there is a public interest in concluding a case successfully, rather than maybe run the risk of an acquittal or, a case falling apart. But it is a fine line, isn't it? In assessing where things are at and assessing the public interest. But do you think this hanging over potentially would give Crown prosecutors something additional to consider? Like, am I going to get called out here or embarrassed by police and that sort of thing? I
don't think most prosecutors would ever think that would happen. They
Right.
might now, but it's and that's what you do is you look at okay and you balance it and what's the evidence that we've got and everything. And that's one of the things that really got my attention too is that when you read all the media stories, there's no real clear explanation of what the actual evidence was that the police and the Crown were relying on about how this woman killed the little girl. It's very fuzzy.
Yeah.
And if that's the case, that's a weakness for the Crown in the longer term, because the onus is on the Crown to prove the case beyond a reasonable doubt.
Right.
So I don't know because I don't know anything about the files, but those are the kinds of things that I think may have been at play here.
Yeah. And it does seem, you mentioned Edmonton's police chief, who was the interim chief when he wrote this letter. He's now, in the position fully. He seems to be backing away a little bit, or maybe trying to rebuild that relationship. So maybe this is a case of, okay, we sort of made our point and let's get back to a working relationship. Do you think?
That was my impression as well, too. And I must admit, the thing that really leapt out for me was that the head of the legal division for the Edmonton Police, who did the media content, and I saw a little bit of it, and I thought, pretty impressive. Because her former employer was the Crown.
Yeah.
Bet you she's got some insights,
Yeah.
about things as well too. But who knows? Who knows? That's why just the long run of this is, I think, hopefully both sides learn from this, both the Crown and the police, about the importance of the working relationship. The police shouldn't have to go months without getting communications on a case of this kind of significance.
Yeah.
And I don't know the details of, and on the other guys that were charged with things, like how long did they have a criminal history? I'll bet you they probably did, given the fact that it sounds like they were denied bail. But, those are all the kinds of things that you have to look and say, well, why did the system, not intervene to stop this woman who seems to have, if you read the details of what they were doing that night, doing drugs and drinking. I mean, is this really the kind of person that should be having custody of an 8-year-old girl? Like, I guess she would have been 6 when she got custody of her, so I don't know. But the best way to get at it is to find out what actually happened and what could have happened and what should have happened, and to learn from that so it doesn't happen again.
Yeah, absolutely. Well, let's hope that happens. Scott Newark,
Yes.
We'll leave it there. Really appreciate your insights on all of this. And again,
Nice
thank you so
talking
much
to
for
you,
making
Rob.
some time for us here.
All right. See you.
All right. Well, joining us now for some further perspective on this case in Edmonton and some of the important issues this highlights. Very pleased to be joined on the line, Alberta, by Deborah Hatch, an Edmonton defense lawyer, also an Alberta director with the Canadian Council of Criminal Trial Lawyers. Deborah Hatch, so great to have you with us here.
Thanks very much for having me, Rob.
First of all, let's talk about just how unusual or unprecedented it is to have the Edmonton Police or police anywhere speak out in this nature about a plea deal. I mean, have you ever seen anything like this yourself, first of all?
This really is unprecedented. I've been doing this now for 26 years. I have not seen the police trying to influence an active prosecution like this before, and I certainly hope we won't see it again.
It's some interesting comments from the new Edmonton Police chief saying he hopes they don't ever have to do this again, and maybe now wanting to rebuild relationships with Crown prosecutors. Does that suggest to you maybe that they feel perhaps that they went a little too far here? What do you read into that?
Well, it suggests to me a lack of understanding, a lack of appreciation of how truly bad this was. What we should be hearing from the new chief is a recognition that this should not have occurred. It doesn't matter how upset the police or any other interest group is with the prosecution. The prosecution has to be independent, has to be allowed to be independent. If we want to have, the rule of law, there has to be the separation between the police and the Crown. And we should never see threats from the police service, their membership, or a lawyer representing them to the prosecution saying, if you do this or you don't do this, here's what we'll do. So we should never see that again, and we shouldn't have seen it on this occasion. And the police chief should be recognizing that and publicly apologizing for it.
Right. So not just backing away from it, you'd like to see something a little more definitive from the police chief.
That's right. There needs to be this kind of recognition. Otherwise, are we going to see this again the next time the police are feeling upset about something? I mean, the Crown's role is to represent the interests of the public, not the police or other people or other interest groups. And we all want to see that distinction maintained. And the police have to understand that. They just have to understand it.
Right. What is that domino effect then if there's a concern on the part of Crown prosecutors that they're going to be called out or embarrassed or shamed in some way by the police, and then the nature of the whole proceedings, where the defense fits in? What is the domino effect of having this factor?
Well, that's exactly it. You don't want there ever to be a chill on the prosecution where the prosecution feels they have to look over their shoulder when they are making a decision that is supposed to be an independent one. The police don't have the same ethical constraints that lawyers have as members of the Law Society. And the prosecution, it's been recognized in many cases over many, many decades, the prosecution acts as a quasi-judicial body. So they have to be able to make these decisions independently. And if they are looking over their shoulders or feel that they are looking over their shoulders or feel that they could be punished by the police, or that the police will improperly release some information or take some other action if they do something or don't do something, that has a real effect on our society.
Mm-hmm. This case has taken on a lot of significance, I think maybe because of public perceptions around the criminal justice system, but to then have the Premier of Alberta weigh in and actually defend the actions of Edmonton Police. What did you make of that? And what kind of impact could that have?
We expect that our elected officials understand the basics about the lines that have been drawn in our system. And you would expect especially the Premier of a province would understand, first of all, you don't weigh in on an act of prosecution. And second of all, you don't support the police when they are stepping on the toes of the prosecution. So if she doesn't understand the lines and the significance of them, that's really unfortunate.
Mm-hmm. I think it's true of this case. It's probably true of a lot of cases that maybe end up in plea deals or are going to trial, that there's a lot that we don't understand. There's a lot that people don't see about different aspects of a case or different kinds of evidence. And you got a situation where everybody's weighing in now. Everybody's got an opinion, but there's probably a lot here that maybe people don't fully understand or appreciate. Is that fair to say?
That is very fair to say. Yeah, it's the prosecution who has the police investigation in their hands, but B, they'll have other information from other sources, from counsel for the accused, or perhaps other parties. There are things that the police are not privy to, and there are things that the police sometimes don't understand. And prosecutors just have to be able to make those decisions independently.
The whole nature of a plea deal, and there's that real dilemma at times, I suppose, for the Crown in the benefit of avoiding a trial, putting a matter to rest, and the risk of going into a trial and the uncertainty of the outcome there. So what goes into a plea deal from both the Crown's perspective and also from the defense side? Because not every case goes this route. So how do these come about in the first place?
Yeah, well, one thing that goes into it is you've got the prosecutor who is a lawyer who understands the test to prosecute something, a reasonable likelihood of conviction, and the public interest. And prosecutors have to continually weigh those concerns when they're assessing, do we proceed with this? What charge do we proceed with? And should the case be resolved in a certain fashion? Now, if the prosecution were to run every case to trial, the courts, which are already overburdened, would just completely collapse. That's just simply not possible, and it's not in the interests of everybody to have that. So many cases result in guilty pleas, and the Crown is assessing what is an appropriate plea, what facts can be admitted, what could we prove in this case, and what could we not prove. And it's lawyers who understand the law and the legal tests, and the police have their own interests. And they've conducted the investigation. They may feel certain evidence is admissible. They may simply, be wrong about that. So it's for the prosecutor to make that decision.
What about on the defense side? What is the role then that defense attorneys play in that process?
Yeah, so the defense lawyer plays a very important role in that process, evaluating the evidence. We receive disclosure, which is the information that is on the prosecutor's file. We'll review that. We'll assess what, if anything, is provable, and what are the issues in the case. And it's for the defense to, often have discussions with Crown Prosecutor about what is provable, what is not, why that would be the case, and various other elements of the case. It's also for the defense lawyer to sometimes bring information to light and provide that to the prosecutor. It's certainly not required or compelled, but often the defense lawyer will want to do that. And in that way, you've got two lawyers working, different sides of a case and coming to, a position where either the case is going to be run and it's going to proceed to trial, or it's going to be resolved and there's going to be a guilty plea, or the charge is going to be withdrawn or stayed. And that's how it works.
So if there's a situation where there is external pressure on Crown prosecutors, how does that affect then how a defense attorney would approach a case, or even moving forward, if there's even that question that there could potentially be that sort of outside pressure? Does that affect the assessment or the role that criminal defense attorneys play?
It can, and I'm not going to speak specifically about this case. Sure. Wouldn't be appropriate to do so, but I would suggest that, generally, if it is felt that there is improper influence, then, the defense will have to consider what are the implications of that for the case. Is it threatening the case? Is the accused going to get a fair trial, an appropriate, proper sentencing hearing? One would hope so. Certainly, we have an independent judiciary. We work with Crown prosecutors as defense lawyers, and are impressed with the independence of the Crown's office, and we expect that. But if that is compromised, it does potentially lead to some big issues. In other cases where some part of a prosecution is compromised, the defense can consider bringing an application to stay proceedings, to have charges thrown out, because the conduct that you see is shocking to the public conscience. That's one of the tests for a stay of proceedings. So, we don't want to see cases, coming to that point.
Well, and I'm curious, too, how judges might see all of this. If some of that independence is threatened or undermined, if it calls into question other aspects of these cases, and what sort of a stance do you think judges might take on that?
Yes, again, I'm not going to comment on this case, and I certainly wouldn't do anything to prejudice this case. But generally, a judge will potentially have to consider if something is going on that's unusual in a case and it's brought to a judge's attention, applications can be brought, and you really risk a case when you take actions which could compromise the independence of the Crown, the independence of the judiciary, independence of the defense bar. All of these spheres have to be able to operate properly for the system to work.
Does it feel like we're at a bit of a tipping point here where either maybe this becomes more common or even becomes the norm, or the alternative where everyone just sort of takes a step back and said, okay, look, we are frustrated, there's concerns with certain cases or how certain things are being handled, the point was made, maybe an opportunity to take a step back. Do you feel we're sort of at that moment right now?
It's certainly an opportunity for people to reflect. I think it's an opportunity, and that's part of why I'm happy to speak with you today, is because I think it's important that the public be educated about why this cannot be the norm. People need to understand that this is really unusual and that it's not a good thing. The police need to understand that this cannot happen again and that it should not have happened. And, I would hope that we won't ever see this again. We've all seen some of the things going on down south and in other jurisdictions. And I think, we would like to keep our system a properly functional one where the rule of law is what we care about and what we act to protect and to promote, and where we do that at every step that we can. And that includes all parties. That includes, prosecutors, defense lawyers, and police officers staying in their lane where it's appropriate.
Well, I guess we'll see what the fallout is from here. But Deborah, we'll leave it there for now. Appreciate your insight and perspective on all of this. Thank you so much for joining us here.
Thanks very much for having me.
All right. Well, our thanks once again to defense attorney Deborah Hatch. Also, our thanks to former Crown prosecutor Scott Newark. So a couple of interesting perspectives on this case. And I think it is an important case. It remains to be seen, I suppose, what the fallout is, or whether we see more of this, more police forces speaking out in certain cases, whether it's an opportunity maybe for everybody to take a step back and sort of reflect on where we're at. I do want to let you know as well, our colleague Matt Gurney has a piece up at readtheline.ca on this case. And while it is shocking to see Edmonton Police respond publicly like this, maybe our system needs this kind of a shock. So you can read Matt Gurney's thoughts again at readtheline.ca. And this is tricky because public faith in the system is important too. And accountability should exist with those tasked with making these kinds of decisions or making these plea deals. And maybe they're not always right when they do so. But it is unusual to have police speaking out against that. Right? There's an obvious public interest in any case involving the death of or a murder of a child, but there are lines and processes that need to be followed by everybody involved, all the relevant stakeholders, and it's really important that we maintain that integrity in the system. So a lot of strong feelings on all sides of this. And again, we'll see what ultimately the fallout is from this case, and whether we see more instances of police speaking out, whether everybody takes a little bit of a step back here. So more in this case, as mentioned, from Matt Gurney at readtheline.ca. That's where we will leave it for this episode of the Line Alberta Podcast. Much more at alberta.readtheline.ca. My name is Rob Breakenridge. We'll talk to you next week on the Line Alberta Podcast. Take care.